Bill of Rights is the first 10 amendments to the Constitution. These amendments focus on the specific personal freedoms that were not listed in the Constitution itself. During the ratification debates, opponents of the Constitution, known as anti-federalists, raised the objection that the new government under the Constitution was too powerful and would trample the rights of Americans. To ease these fears, supporters of the Constitution, known as Federalists, agreed to a Bill of Rights once the new government was in operation. 12 amendments were proposed in the first Congress, and of these, 10 were ratified, which became the Bill of Rights in 1791. The rights in the Bill of Rights cover a variety of things, such as freedom of the press, freedom of speech, a right to bear arms, protection against unreasonable search and seizure, and guarantees of due process and trial by jury. These rights seem quite diverse, but all share a common concern: an overreaching federal government. Ultimately, the point of the Bill of Rights is to limit the power of the federal government by listing personal rights and freedoms that cannot be infringed upon by the government. There are two important points to note about the Bill of Rights. First, the father of the Constitution, James Madison, who was a Federalist and ultimately the author of the Bill of Rights, did not believe such a document was necessary. For Madison, the separation of powers and the checks and balances embedded in the Constitution would keep the federal government so busy fighting with itself, the people's rights were in no immediate danger. Second, Madison further opposed a Bill of Rights because not only was there no way to list all the rights that belonged to the people, but a Bill of Rights was ultimately just a piece of paper. In an emergency, when the people were crazed with whatever issue was gripping them at the time, a Bill of Rights would not stop the government from trampling on people's rights. Our history, unfortunately, has shown that Madison was not wrong on this point. Initially, the court saw the Bill of Rights as applying only to cases dealing with federal law. In other words, Bill of Rights protections were not guaranteed at the state level or against state laws. In the early 20th century, though, the United States Supreme Court began to utilize what is called incorporation theory. Here, the Bill of Rights was incorporated into state and local levels as well. As a result, today we consider our Bill of Rights protections to apply universally, regardless of what level of government we are dealing with. The Bill of Rights is an important embodiment of natural rights theory as well. In other words, the rights contained are not rights for Americans, but rights possessed by all people simply because they are alive. None of the amendments express that they are limited solely to the citizens of the United States. Some, such as the Fifth Amendment, are more explicit, using words such as no person, or the rights of the people, or the accused, to demonstrate their application to all people living in the United States, not just citizens.